Good. So, Albert, not Albert, kindly introduce yourself, tell us your name and the class you are in, Albert.
Okay, thank you so much. Good morning, panelists. My name is Katana Albert Charo. I am a member of Class F Farm 19. My admission number is 2026-0857. And I'm glad to appear before you this morning, and I'm ready to take up the conversation.
Albert, who is your lecturer for conveyancing?
My lecturer for conveyancing is Mr. Steve Ayera.
Okay, thank you. Kindly tell us the difference between a caution and a restriction.
The difference between a caution and a restriction. A caution is placed on a property to warn any person that could be having a further dealing on that property from conducting that dealing until further determination by a court or a competent authority is made. A restriction, on the other hand, allow me to recollect my thoughts on restriction.
So by allowing you to recollect your thoughts, is it a pass? Because I'm willing to do this. Okay, sir. So to avoid any postponations, I've decided to give answers while you're still on your feet, question per question. So when you're asked that question, you can decide to separate it in three angles. You start by who triggers which route. A caution is lodged by a private claimant who has a claim or a beneficial interest in that property. Okay, that is one. Then for restriction, it is entered by the land registrar, sometimes prompted by a complaint as a regulatory or administrative control. So basically, for restrictions is entered by the registrar. Then you divide into purpose. A caution preserves a claimed interest pending resolution, while restriction is used to prevent fraud or improper dealing or addresses sufficient cause. Okay. Then lastly, you divide it by how they are lifted. For a caution, Section 73, you require a notice, a process, or withdrawal or a court order. Okay, so this notice is issued to the person who lodged this caution. Then there is a hearing to be conducted after they have been served. For restriction, on the other hand, it is provided in Section 78 of the LRA. Removal is through variation by registrar after the hearing or by court on proprietor's application with notice to registrar. So for restriction, the courts have a upper hand because they can even direct the land registrar not to do anything and he must comply with the orders. So Albert, the next question. You are a student at the Kenya School of Law this year. Kindly tell us the vision of the Kenya School of Law.
Kindly pass.
Okay, so the vision of the Kenya School of Law is to be a preferred center of excellence in professional legal training, research, and consultancy in the East African region and beyond. So Center of Excellence in Professional Legal Training, Research, and Consultancy in East African region and beyond. Albert, still on the same thought, there was a stakeholder meeting between Kenya School of Law and CLE this year. Kindly tell us one of the reforms that you would like to be adopted in this stakeholder meeting that amounts to the future of the legal education in Kenya.
Okay, thank you. From that meeting that was conducted between KSL and CLE, its purpose was mainly to harmonize the education, or rather the curriculum that students undergo, and harmonize it with the expectations of the CLE. So one of the resolutions that I would recommend is that there be a joint task force or a committee that comprises of members both from the KSL and members both from the CLE. And I also have an understanding that we also get independent members who are usually engaged for the marking. So we have a task force that comprises members from both those parties such that they can harmonize the contents that the students are taught at the Kenya School of Law and the expectations of the CLE and the expectations of the markers, such that people can be aware, or not really be aware, but strategize themselves according to the expectations of both three parties.
Thank you, Albert. That was an open-ended question, and you have correctly scored. Albert, you have been taught civil litigation. In civil litigation, you have been taught, or you ought to have known of the judicial review process. Tell me the two leaf stage, the two prong that you are going to use for you to seek judicial review pursuant to Order 53, not under the Constitution.
Pardon, what?
Kindly tell this panel the procedure that you are going to use and which document you are going to file when seeking judicial review, but this time you are approaching court using Order 53 of the Civil Procedure Rule.
The two methods that I would approach court, basically.
Yes.
Number one.
Yes, what documents?
I can approach the court via notice of motion application, seeking leave to bring the judicial review to have a certain authoritative decision be reviewed by the High Court, or I can also use the chamber summons applications.
You have partially scored because you use chamber summons to seek leave together with a statutory statement that contains the names, relief sought, and the grounds. But on the substantive stage, after you have been granted leave, you approach court through a notice of motion together with a supporting affidavit. That is the key distinction. Then, Albert, you are aware of the Utumishi fire tragedy. Which issues are arising from the same? Kindly give us main issues arising from that fire tragedy.
Okay.
When it comes to the legal aspect.
From the Utumishi fire tragedy, many issues are arising that will be placed before court for determination. However, as you've aptly put it, the main issues, according to me, that will be there for determination and will have a hot debate. One will be the issue of the evidence that is being intended to be relied on, whether the evidence obtained from the CCTV camera was first lawful in light of them being alleged that they are in violation of Article 31 on the privacy of the students. Another issue that will be raised is whether the children can be criminally liable to the offenses of arson or murder that they committed, considering that they have not attained the age of the majority and that at their age they cannot be taken to the normal trial just like adults. So those are the two main issues that the court will be determining and the two parties will be raising.
Thank you, Albert. Still on Utumishi, can a kid be subjected to a death penalty?
Can a kid be subjected to death penalty?
Yes.
No.
What is the legal basis?
I can't recall the exact statute of it, but my general understanding is that a person under the age of 18 years cannot be subjected to death penalty.
Good. If you read Section 238, 1 to 2 of the Children Act 2022, it says that no imprisonment and no death penalty may be imposed on a child. But it goes on to say in Section 82, 3 of the Children Act 2022, if the child was sent to a rehabilitation school, the committal order cannot run beyond the age of 18, and it is a maximum of 3 years. For capital offenses, e.g. murder, death sentence cannot be recorded if the offender was under 18 at the time of the offense. Penal Code historically provided detention at the president's pleasure instead. This is pursuant to Section 25(2) of the Penal Code. So, Albert,
Yes.
kindly tell this panel what happens to the most failed question this year in criminal litigation, question 1, where a minor 17 years old committed an offense in conjunction with an adult of 19 years. So in this situation, kindly tell this panel what are the factors to consider when it comes to detention of these two people and the trial of the same, and how can you generally, what are the factors for you to consider, because the question was that was asking that way.
Okay, thank you. In an instance where an offense has committed and it involves two accused persons, that is, one is 17 years and another one 18 or 19 years, basically a minor and an adult, some of the factors that will be considered during detention, number one is on the age. For the minor, it is a general rule of law that the minor should not be detained together with the adults. So they should be held in a separate place pending trial or investigations. That is the general rule. While on the part of the adult, if arrested, the adult can be detained in a place where other adults are detained. Another factor will be the gender. If the minor is a female, they should be detained together with other female minors in a special place where the children are detained. The same shall apply to the adult person. However, in respect to the question that you're asking, April Criminal Litigation 2026, the adult was not detained immediately because he managed to escape arrest. So by the time he was being arrested, the minor had already served some substantial days in custody. Now, on the second issue of trial, what did you ask about trial?
Basically, are those kids who committed an offense together with adults tried in the same court?
No. Okay, they might be tried in the same court, but for that case, the charges were different. Because one, the minor was going to be tried for accomplishing, or aiding, or abetting that crime, while the adult was being charged of committing the exact offense of defilement. So for the purpose of bringing it into context or showing the parties involved, one of the charge sheets might read that the involvement of the minor. So he might be involved to that extent only, but not to the full trial.
Well, now, what about murder charges? Will your position change?
For murder charges involving a minor?
Yes.
Involving a minor and an adult, or a minor only?
a minor and an adult, will they be tried in the same court, or the minor will be tried in the children's court and the adult will be tried in the normal courts?
Okay, my position will still be depending on the involvement. The minor can be, there is an extent to which you can involve the minor in the trial in the normal courts, and then the other trial be conducted in the children's court. Let's say if the minor is required to answer some questions maybe during examination or cross-examination that will help the prosecution and court reach a determination in the normal court, the minor might be involved to that extent only. But of course, through a special procedure where their identity will be concealed and it might be heard in camera, so something of that sort. But the normal procedure, it should be tried in the children's court.
Okay, Albert, now listen to this decision. Court of Appeal decision, MMM versus Republic 2014, Kenya Law Report. The Court of Appeal held that the Senior Resident Magistrate Court lacked jurisdiction to try the appellant, who was a minor at the time of the offense, as the Children Act requires that all offenses involving minors, except murder or joint charges with adults, be tried in the children court. So I believe that will have answered your question. If there is joint charges and except for murder cases, will be taken to the normal courts because you committed in presence of adults. So the other question, Albert, do plea agreements apply in sexual offenses situations when it comes to the general knowledge of the same? Will the DPP accept to enter into a plea agreement where a defilement case is the one at play?
Okay, thank you. Based on the general knowledge, a plea agreements are not allowed in sexual offenses cases.
Thank you, Albert. If you read the ODPP guidelines in prosecution on children with conflict with the law, plea bargain agreements are not allowed in defilement cases. Albert, what is diversion in when it comes to the DPP powers? One of the powers that the DPP has is called a diversion. What is this diversion?
Okay, thank you. My understanding of diversion is that it's a process where the DPP is allowed to compromise some of the charges of prosecution of accused persons involved, especially if they are minors, instead of going to the normal trial process. If it's involving two minors who are about to negotiate or agree on the charges and have it settled out of court, then they can apply for diversion through court, and the court will consider the grounds of the application and may allow the parties go and resolve their issues without the matter having going to full trial. Some of the times the court is always hesitant if the perpetrator has committed an offense to a minor is an adult. So diversion, at least I can say for the occasions which have interacted with applications for diversion, it's if either both the complainant and the accused are not of the age of majority, chances are high that it may succeed. Or if both of them are of the age of the majority. Another factor is the court will have to consider the seriousness of the charges or offense and see if diversion will serve the purpose of criminal justice, because there are objectives of the criminal justice system to restore and many other factors. So after looking at the ages and the general implication of having the diversion, the court may either allow or not allow the application for diversion.
Thank you, Albert, for that. You correctly scored in your first sentence. So now at least it is also revealing that you could have scored something, but when you continue speaking, you can even dilute your content or waste time, special time for the panel. So you correctly got the question, because diversion is where the DPP decides now this skill will require to go under a postal, not a postal, under an alternative mode of charge as compared to the normal court pathway. But it is not to say that you are going to walk scot-free. You can be taken to a community service depending on the veracity of such factors. If you have mental issues, you can be taken to a physiology so that they deal with you. So the first paper, April 2026, there is a report that says, okay, it's an informal report, that students applied the wrong test when they were doing a 5-2B application. So Albert, this is to be opposed upon you. A 5-2B application is generally what kind of an application? Then I come now to my question. What is a 5-2B application?
My understanding of 5-2B application is an application made to the appellate court to seek leave before lodging the appeal.
Albert, that is erroneous. Rule 5-2B of the Court of Appeals Regional Jurisdiction grants the parties, any aggrieved party, to file an application seeking stay of execution as he intends to appeal. And one of the elements of this application, because if you have failed to define what is a 5-2B application, that means you could have failed even in the elements of it. One of the elements that will make you to be granted this 5-2B application, we have the test that has been laid down through judicial pronouncements, and you have to prove number one, that you have an arguable appeal, plus it is not negative.